Okay. Okay.
All right. Hi,
And
everybody. This is Kim Zadel with Decoding Dyslexia, Idaho. And tonight we have Mert Burns, who has been in the field of education for over 40 years. While in college, he worked as a paraprofessional in a high school program serving students with learning disabilities. He graduated from California State University in Fullerton. Woohoo! I'm from that area too. With a bachelor's degree in psychology. He went on to earn general education and special education teaching credentials. He taught what would be called today an extended resource room while obtaining a master's degree in educational administration from Cal Poly San Luis Obispo. That's where my daughter went. And he worked as a special education principal in California before moving to Idaho. In Idaho, he has worked as a school administrator and director of special education. In addition, he has taught special education classes as an adjunct professor at NNU, has worked as a dispute resolution contractor for the Idaho State Department of Ed for the past 10 years. In that role, he conducts facilitations, mediations, and complaint investigations. And so with that, I will let Mert take over. And thank you for doing this for us, Mert.
oh, you're welcome. You're welcome. And I see that, did I see Letha Blick come on?
Yeah, she came on and then I don't know where she went.
Well,
There was some noise in the background and so I had to mute her.
well, that's okay. She probably saw my name and decided to get off. So no, I'm teasing. It's Letha and I have a great relationship, and I've done dispute resolutions out in that district. Well, what I wanted to talk about, I'm going to put this on share screen. I know you have these materials. There should be 2 pages of these materials that give a great description of the different processes that we have here in special ed. Now, what I'm going to talk about when we look at the top of the page, this talks about it's a quick guide to dispute resolution, and the second page just talks about some differences. What I want to talk about, because these are by far the most common dispute resolution practices, is going to be the facilitation, the mediation, the resolution. Unless there's a question, I'm going to skip that because a resolution is unique to a due process hearing. And we don't see many of those in Idaho. I am not a process hearing officer. I do the facilitation, mediation, and complaints. Due process is has a unique set of rules. And if there's an interest in this group, I can recommend one of the other contractors with the state that do process hearings. And so I'll talk about the written complaint, mediation, and the facilitation. So my plan is not to read this whole thing to you, but to walk you through it from my perspective as a facilitator mediator, and then open it up to questions that you might have as it might apply to your child. So let's say, Elizabeth, if you don't mind me using you as an example in this case, let's say that Elizabeth is going to have an IEP meeting with the district or with the charter. First of all, there's no cost to you. There's no cost to the district. My services are provided by the State Department. And what I would want, what it would look like, Elizabeth, is let's say you feel like there's a need for facilitation because in previous meetings, the team just hits roadblocks. Or sometimes I hear from parents, district's just not listening to me. Or I feel comfortable with someone else in there besides myself. you can ask for facilitation, the district can ask for facilitation, and what happens is you would contact the State Department, and if you made the request, the State Department's going to contact the district and say, do you agree? Because both parties have to agree. And let's say you both agree, then what I'm going to do next, the next step that I get after I'm made aware of this is I'm going to give Elizabeth a call. I'm going to give the district a call or the charter school. And I'm going to do a couple things. One is I want to introduce myself. Secondly, I want to make sure that both the district, the school, and the parents have a clear idea of what the process looks like. I don't want the school to go in there or a parent to go in there unclear of what my role as a facilitator is. And so I kind of, and you may know already because you'll be sent information from the state, but I like to personalize it to see, you know, do you have any questions about the process? And then after we do that and do some housekeeping in terms of setting dates, what I'm going to find out is I need you as the parent and I need the district to help me build the agenda. And so the agenda might be, I want to talk about, Kim and I were talking about a case she's working on where there's some impasse regarding areas to test in. And so it might be about testing, might be about adult support, it might be about curriculum, how much time should the child be pulled out or pushed in. So there may be one or more issues there. And one of the things that I would call the district, ask them the same question, because I don't want Elizabeth to walk in there and be taken by surprise. And I don't want the district be surprised. So after talking with the parent, I'm going to call the district and say, here's what the parent would like to see on the agenda. And do you agree to that? Or is there anything you want to add? So that I don't want Elizabeth or any parent to get surprised with oh, by the way, we also want to talk about school attendance. Oh, we want to talk about homework. I believe both parties should be made aware so that you can adequately prepare. And I don't do well with, oh, by the way, approaches to meetings. And so I approach it in a way that the parties are clear on the agenda. One of the things I would highlight for facilitation is this is a regular IEP meeting or eligibility meeting or assessment team meeting or a behavior plan meeting. I'm there as a neutral third party. And so all the rules that apply to IEP teams would apply to a facilitated IEP. And by rules, I mean, as a parent, you get to be notified who's going to be there. They have to schedule it at a time that's convenient. So there's no unique rules to a facilitated IEP other than I'm there as a neutral third party. And I make that clear to both parent and district. I am not there as a parent advocate. And I am not there as a district advocate. If I do my job right, I should look neutral. And what that means is, let's say once again, using Elizabeth as an example, her 11-year-old, let's say there is you're talking about a reading goal and it's a fluency or comprehension or whatever it is. I'm not there because I don't know her child. I'm not there to say, oh, that's a great goal, or he really should have speech therapy, or this accommodation is appropriate. I'm not there to weigh in on that because I'm neutral. And it's easy for me to be neutral because I don't know the child. My focus is on the process. And my approach to the process is I want to establish and promote a meeting environment where the whole IEP team can feel safe to express opinions, to disagree, to not be critiqued, either verbally or non-verbally. And I say non-verbally because I'm working on a complaint in another district. And one of the things the parent told me when I was talking to her is that at the last IEP meeting, the assistant principal rolled her eyes at her through the whole meeting. And so, we can have verbal tension in the meeting, but a lot of it comes from nonverbals. And so I'm there to promote a meeting where people feel safe, feel like they're being heard, and they don't feel attacked and they don't attack anybody else. And the reason that's so important to me is as soon as we start dealing with either, I don't want to say aggressive behavior, but hostile behavior, we stop talking about the child. So if a district says something to you that sounds snippy or something like that, you either get angry or defensive, and that's human nature. I believe, and I don't think I'm naive. I know we come into these meetings with some level of tension, but I really believe that the team can focus their discussion on the needs of the child without making anybody feel like they're in the hot seat. And it doesn't mean that we can't have conflicts, because there may be. But if you go to this site on the second page, it identifies, this came from Cadre, and that is, I always forget what it, Center for Appropriate Dispute Resolution in Special Education. There'll be a website on the second page. They have wonderful information for parents and districts, and they're not district advocates, they're not parent advocates, but it's about that whole process of dispute resolution. Wonderful resources. It's all free. It's a federally funded program. And so like I'm using this, it's a public domain. And I talked to the director and she says, oh yeah, share it with the parents. And that's just fine. So that's what facilitation looks like. So we've built the agenda, and then I'm there in the meeting, and my job isn't, as I said, at the risk of being redundant, I'm not there to tell Elizabeth that her ideas are great or that the district ideas are great. I'm there to really focus on the process. And what that process looks like is most all of the discussion should be about the child. It's not about teachers or parent. I mean, if there's concerns in those areas, there's other ways to handle it, but that's not for the IEP team. And let me give you an example. I was at an IEP today, a facilitated IEP, and I won't mention the district. The several issues were on the agenda. Parent also had concerns about some staff behavior. And so in the pre-meeting discussion, we talked about the fact that if you have concerns about staff, we want a parent to be able to say that, but there's nothing an IEP team can do about it. That's more of an administrative issue. So we had the IEP meeting, and in this case, we happened to develop a plan to decide what data the parent and district needed to consider changing the child's placement. And then the parent, it was prearranged that afterward, the two parents were going to meet with the director, talk about those staff issues, because the director is someone who could do something about it. You think of who's at an IEP meeting, and you've got your gen ed teacher and special ed teacher and SLP, et cetera. Well, if a parent is concerned about the behavior of a staff member, the SLP can't do anything about that. And the gen ed teacher can't do anything about it, but a director can. And so typically that, and I've even facilitated meetings like that at parent and district request, but it's not part of the facilitation. Okay. And then the facilitated IEP is probably the least formal. It's you can take notes in the meeting, you can record the meeting, all the things that you can do in an IEP meeting happens in a facilitation other than someone like me actually facilitates the meeting, is that neutral third party. And my goal in the meeting is to make sure that all voices are heard and to keep the team moving forward, but covering issues sufficiently so that the team can make a decision. Okay. With that, let me, before I go on to mediation, I want to see if there's any questions that you have about facilitation, or have you been involved with facilitation yourself? Any questions or experiences you want to share?
Mert, do we want them, since this is a small group, do you want them to just ask?
You know, that's what I was thinking. You and I had talked about maybe doing it through chat, and but with this smaller group, we certainly can just take questions if there are any.
So is this then what you would hope for, is that this facilitation meeting could be, I guess, work well enough that you wouldn't then move on to other options? Is that kind of the hope?
That's the hope. And what I find is that if the district and the parent advocates can follow just certain courtesy protocols, it doesn't harm the relationship. I've seen teams really be able to work through an issue, and at first it looks like an impasse, but then we try to resolve it through this method. And I know when I walk out of the room, district and parents still need to work together. So I want to do anything I can that preserves the relationship, because the parents I talk to, they don't want to be known as the tough parent. They're going to work with the teachers in the future. A lot of the parents that I work with are really supportive of the schools, even though they might not like a certain component of the IEP. They're involved in the parent organization, the PTOs and the carnivals and all that. And we don't want to ruin that if we can avoid it. So I really try to leave the meeting feeling like, boy, you know, we can, parent and district can really partner now. We had a rough patch. We were honest, but we got past it. And as a parent, you feel now that you can work with that district. Doesn't always happen, but that certainly is one of my goals.
How long of a process is it from me contacting the state board or the state department, right, to when this would happen, this meeting might happen?
Gosh, there was the one I did today. It just came to the State Department's attention last week. So it can happen pretty quick. Sometimes it varies throughout the state. Like the one I did today was close enough that it was in person. Others, it's virtual meetings. And some I've been involved with, Kim, where sometimes it's a combination, and some people can be there and some people can't.
And sorry, I have another question.
Sure.
Does this look bad on the school district? Like if parents are going, does this affect like their grade, or, you know, can they get in trouble if too many parents are calling for a facilitator?
I would say not in trouble so much, but if we see that certain districts.
Letha, I need you to mute, please.
Yeah. Extra long, and they didn't have a bunch of
Mute.
they had 8 extra long.
That's good.
Yeah, they fit almost better than this print.
Okay, sorry about that.
That's okay. So Elizabeth, that's a good question. And I would say generally the district doesn't get in trouble. What happens though, when I start talking about complaints, we have what is called a systemic complaint. And that means more than one parent has filed a complaint. And if the State Department sees a pattern, and so I don't know what it would be, but like in a district your size, there might be a certain number where every facilitation requested is about developing behavior plans. State Department then is going to say, okay, do these guys need some coaching? We keep getting requests for mediation. We keep getting complaints. We keep getting facilitation requests. And it seems to be around this one subject. And then so it's not in trouble, but the director is probably going to have a conversation with the special ed director saying, hey, we're seeing a pattern here. Give us your thoughts on it. But it's not like a district can only have 5 or more facilitations. The other part that they would look at is, are they resolvable? Are these things getting resolved, or are these going on up the chain to complaints? Does that answer your question? Thanks. And any other questions about facilitation? Let's see
Mert,
if
I have one on the eligibility. So I don't know if you want me to ask it now or wait.
No, go ahead.
Okay, we've had some districts say that you can only have one category for eligibility, and others have saying like 2, like the child say is other health impairment because they're ADHD, and then they have dyslexia. So can they have 2 on their plan?
I'm going to give you a kind of an attorney type answer. Although no upfront, I'm not an attorney, but I've been around special ed a lot. My response is it depends. There is nothing that prohibits a district adding a secondary or tertiary eligibility category, but it's not required because the district only and it's simply for data purposes. They report, here's how many kids we have with learning disabilities, with cognitive impairment, with speech delay. And so you only need one. And this is just Mert talking, when you deal with kids with learning disabilities, that it may be one diagnosis, but that's not a comprehensive picture of the child, because often they'll have receptive or expressive language issues. There may be some behavior issues because of frustration. So it may show up in their handwriting skills. So it's like saying a child's on the spectrum. Well, that's a category, but it's really not a very good descriptor of the child. What I would look for, what I'd invite you to consider is if the parent, if you believe that the child is dyslexic, is whether the district agrees to put it on the eligibility. When you look at all the results on the eligibility, do they describe the dyslexia, even if they don't use that word? When you look at the impact on education, it could show up on the IEP in the present level of performance. It could show up on the eligibility. So for me, I'm not just looking at eligibility. I'm looking at, have they adequately described the child? And is it, when you look at that language in the eligibility, is that the kind of thing you want to look at?
Okay, so if a child is eligibility, say, is around the ADHD, but they do have some dysgraphia or some writing process problems, can the goals be on that as well as the ADHD? Or because the category was other health impairment, the goals can only be on a other health impairment, or can we cover the whole areas?
No, in fact, goals should not be written based on category.
Okay,
Any more than services are defined. If you have a learning disability, you automatically get speech, or you automatically get OT. That does neither rule out or automatically qualify you for those services. It's, special ed, IDEA, the first word you underline is individualized. And so you look at all the child's strengths and deficits. And if that child needs a goal in writing, then they don't have to quote qualify for it based on a certain score. If the team determines this kiddo needs writing, whether it's the process of writing or the IEP I was at today, this child is working on putting multiple paragraphs together. And it's not about dysgraphia, it's about the language needed.
right. Right.
I know we have an English teacher here. It's not about, it's their inability to write using sentence and paragraph requirements or guidelines, not because the child has a fine motor skill or a fine motor deficit. Yeah. Any other questions on that? I'm going to move on to mediation. And somehow I may need your help on this.
Can you scroll back up?
I'm going to see. Okay. So that's facilitation. The next thing is mediation. And for this one, let me use, Kim, I'm going to use you on this
Okay.
just as an example. So let's say you have a child and they're receiving special education, they've got an IEP, and maybe you tried to resolve it through facilitation. And let's say you had 5 issues that you wanted to talk about, the team talked about it, and you came to a resolution with 4 of them, but there was a burning issue that the team couldn't resolve. Let's say it was the need for additional adult support. You address the issue of goals and accommodations and the need for support services, but you are just convinced that your child needs a one-to-one aid, and the district is convinced that he doesn't. That can lead to mediation, and that's unique from facilitation. And let me say, first of all, you can file for mediation. You don't have to go to facilitation, then mediation, then a complaint. So you don't have to follow a sequence. But mediation, where it looks different from facilitation is this. It's a little more structured. And mediation is required under IDEA. IEP facilitation is not. And so I think somewhere on the graph, it makes a comment because Cadre did not just write this for Idaho. And so some states like Idaho use facilitation. It's not required. So mediation is, and that's written into the IDEA law. What happens with mediation is, let's say we're talking about that one-to-one aid that Kim wants. That would be the one topic for the mediation. And mediation is different than facilitation in this way. Everything that is said in mediation stays there. You know, it's like the old ad about Las Vegas, you know, what happens here stays here. In the case of mediation, you can't record. If you take notes in the meeting or the district does, I collect all your notes at the end of the meeting. And it's not to promote secrecy. It is to promote thinking out of the box. And so let me give you an example and see if this makes sense. You're in mediation, Kim, and you say, I think my kiddo needs a one-to-one aid. District says no. And then someone puts forth an idea. And the district says, well, Kim, we'll grant a one-to-one aid if you will agree that it just be for half a day, or if it's just in his reading class, we'll give him that one-to-one support. And nothing happens with that discussion. It ends up not being resolved. The fact that things aren't recorded, the way it's worded is information that you share and the district shares at the meeting cannot be used against either party if it goes on to a due process hearing. So for in this case, Kim, the district can't come back and say, well, Kim, you agreed to a halftime aid in mediation. So you're in a due process. You agreed to a halftime aid. Why are you backing out now? You can't do that. And the idea is we want that team to think out of the box. Let's get creative. Hey, does he have to be pulled out for the whole reading period? Can he start in the gen ed class and then move to a pullout? Can he be in some kind of special ed environment when you're first introducing a concept, and then as he gains the skill, can he transition to gen ed? The whole idea is to brainstorm, be creative, think out of the box, and not worry that your words are going to be used against you if it goes on to a due process. But does that make sense? And so what that means is at the mediation, you can take notes during the meeting, but I collect them at the end. We don't record the meeting, whereas we can a facilitation. You can record personally. Sometimes district decides to record. Mediation, you can't. The other thing that's different, and some parents like this, some find it a little more formal. There's only, and this isn't an Idaho rule, there's only 3 people, up to 3 people on either side of the table. And so it's sometimes parents, I hear from parents, I was at a meeting once in a district, and there were 22 participants in the meeting. Well, how is a parent not going to feel intimidated with those kind of numbers? And it was, and I don't know who was more intimidated, the poor gen ed teacher sitting in there or the parent. Both of them were very uncomfortable. And so some parents like the idea of a small group. Some parents don't like it quite as much because you don't have the whole IEP team there. So in this case of the one-to-one aid that we're talking about for Kim, it might be it doesn't have to be 3, first of all, it's up to 3. It might be Kim and her spouse, and she decides to bring an advocate or a community-based therapist. She'd get to pick. District has the special ed director, the school principal, and psychologist. But there's only 3 parties there. It's a good thing in that it's easier to talk in a small group. On the other hand, you don't have the SLP there. If a question comes up about the child's language, you don't have the OT there. You don't have the school counselor. So in some ways, reducing the number of people moves things along. In other ways, then sometimes you think, oh gosh, I wish we had our whoever here to contribute to the conversation. Just like with facilitation, either party can request it. Both have to agree.
Mert, can the parents have any input on the 3 people from the district?
You can have input as to who you'd really like there, but ultimately it's the district call. Most commonly, I would say, because we're dealing with um, something that's maybe a little stronger feeling, in that you thought you could work it out in an IEP meeting or facilitate it. It's still ending up being a barrier and a bone of contention. It's still important to you. You want to resolve it. Facilitation didn't work. So often parents will ask for that mediation. Sometimes they feel strongly enough that they'll ask for mediation first. Now, a way in which mediation is more formal is if you go down, I'm moving up the screen, and it says that underneath a parent or school district may request. If you look at the line beneath that, if there's an agreement, there is a enforceable document. You sign the agreement, district signs the agreement, and that's a legal document. And so if, let's say you guys agree that the aide's going to be there for half the day and you're going to collect data for 2 months and then interpret the results and decide where to go from there. I actually write that out when I do a mediation. District agrees to this. District agrees to collect data in the following areas. District agrees to, or district and parent agree to convene IEP review meeting on or before this date. That's actually written out. It's enforceable. You sign it, the district signs it, and so you have that document. Questions about that? I think I've highlighted that everything. There's no cost to parent. There's no cost to district. If there is no agreement, so Kim, you and the district can't agree on that aid, then at that point, I'm still a neutral third party, and I'm not going to weigh in that, oh, your kiddo needs the aid or they don't, or this certain curriculum or whatever. Excuse me. It just remains unresolved, and you and the district will have to decide, where do we go from here? Is this worth taking it to due process? Is it worth a complaint? What do we do about this? So we either close the meeting with an agreement, or we close the meeting saying we didn't come to an agreement. Questions about that? No?
Yeah, Mert, how often does it have to go to that next step? Or does it usually go to a written complaint at that point if there's no agreement?
The parent needs to consider their options, and the State Department is really good about listening to parents. At least I believe they are. They're probably not going to try to talk you into or out of filing a complaint or filing for due process. What I find is how critical is it to the parent? And so I see some parents say, okay, we're going to try it without the aid district, but I'd like to have a meeting in X number of months to see what the impact is. Sometimes the parents say, no, I'm going to die on this hill. I'm taking it to the next step. It's that I feel that strongly about it. And then at that point, I'd recommend on your procedural safeguards, your parents' rights statement that you receive, there are names and phone numbers of agencies and people to contact, whether it's IPOL, Disability Rights Idaho, State Department of Education. And that's where, as a parent, what I would invite you to consider is somebody talk to me about this. What are the pros and cons of me taking this to the next level? Because it's hard as parents, when you advocate, that's a lot of work, and you're investing time and you're doing research and meeting time. And so it really is, I find it's a personal decision. I work really hard to, once again, not telling one party what to do or not, but I'll say things like, well, I've seen in this situation, I've seen other teams do this. Have you thought about this? Would you be willing to consider this? So I want ideas to get out there because parents don't want to see this move forward. Districts typically don't want to see this move forward. And so if it can be resolved, I find my experience in general is both parties are working hard to do that. But sometimes it just doesn't work out. I dealt with one in northern Idaho, and and we spent a lot of time. I think there were a couple of meetings, long meetings, and at the end, they just couldn't resolve it. We didn't end up signing an agreement. So, any other questions on that? Let me go on to a written complaint. I'm working on a complaint right now. And I obviously I won't say what the district is, but this parent, it's about eligibility. And I know you're interested in that, Kim. In this case, it's not regarding a child with dyslexia, but a district did an assessment and they found that the child was not eligible. And the parent thinks they just messed it up. And she is convinced that her child is eligible. And so she filed a complaint. What I did is just like with facilitation and mediation, I call the parent and I call the district, say, do you understand the process? And once again, I want you to be comfortable with what this looks like and timelines and things like that. And as a parent, sometimes parents think that when they file the complaint, they basically, when you call the State Department, they'll send you a form and you write a narrative. Some parents think that they're required to use legal terms. And you denied my child FAPE. You know, you did not place him in the least restrictive environment. And I'll even have parents that work to cite certain codes. But you don't have to, because what the complaint looks like is this parent wrote a narrative to the state and saying, here's what happened. And they said, here's why he doesn't qualify. And I think he does. And here's outside reports. She basically just wrote me the story. It's my job to take that and turn it into formal allegations. And just so everyone is aware, the State Department can investigate complaints that are related to IDEA only. And that means the identification of a child, eligibility, the IEP, behavior plans, extended school year, all the components of IEPs can be in a complaint. Sometimes what I'll hear from parents is, I don't think the vice principal likes special ed kids. Lunch period is not long enough. You know, you're not serving kids a nutritious lunch. And I don't minimize those things because it's important to a parent, but it may not be IDEA relatable. Mm-hmm. And so it has to be related to the IDEA. So this parent, she wrote about 2 pages of narrative, just in her own words. And then I took that and it turned out to be, there were 4 complaints, solid allegations in there. And then what I do is the parent and the district get a copy of, here's the allegations. We've looked at the complaint and we think these 4 are investigatable. And then what I do is I go through the process of investigating. And typically what that looks like is I look at documents. And so I tell the district what I want to see. In the case of eligibility, you can imagine what I want to look like. What I want to look at is I want to see the eligibility report. I want to see written notice on that. And once again, I can't tell a district, oh, this kid really is eligible, or tell a parent, oh, no, they're not. What I can do is for eligibility, there's very specific protocols. And I forget the name of our psychologist from New Plymouth. Are you still there?
She's still there.
It's Melissa. I'm in CUNA School District.
Oh, CUNA. Okay. So, I mean, you know all the rules regarding eligibility, and it's not a casual process. Am I correct on that?
Yeah, I would agree with that.
And so what I would look at.
We use the special education manual, that the state produces, and we follow the criteria that's in there.
Right, right. And so what I look at is, did the district follow the process? And so I'm not there to second guess what the eligibility team decided. I'm there to see if they followed the process. And where I see districts sometimes fall through a bit is a parent is supposed to be part of that process. So, and by part of the process, what that means is, if this is a new referral, so whether the parent generated it or a teacher or a counselor, something's not working for the kid, right? Behavior, academics, peer relationships, something's not working. Well, based on that referral, a team is supposed to go through and say, okay, we agree that we need to test this child. We don't think it's just related to the fact the child's had the flu a lot this year and has missed a lot of class. We think there's something maybe going on. And it's not going to be settled with a 504 plan. We need to get more information. Well, there's a process to decide what information do we need on this child. Now, if they're 7 years old, one part of the checklist is a vocational assessment. Well, team's going to say, well, we really don't need that on a child this age. But there's basically a checklist that says, do we need to test their academics? Do we need to test their cognitive skills, their language skills, their social skills, assistive technology? There's a list, and the parent should be part of that discussion, and they have to sign, they have to give permission. And then when the team actually meets, that information is given to the parent. And so the parent has a chance to, in this case, with the complaint I'm doing, what I'll be looking at is, did the district follow that protocol? In this particular case, the parent thinks that the district did not consider outside information that she provided. Now, I don't know if they did or not. Sometimes, for some people, you might hear, well, you didn't really listen to me. You didn't really consider it. The district may have proof that says, well, yeah, they did consider it. They just didn't happen to agree with it. And so I'll be looking for notes for meetings or recordings of meetings. So I'm looking at the process, I don't have to worry about me determining if the child is eligible. Now, if they didn't follow the process, then, or for any complaints, if there's a non-compliance issue, then the district has to correct that. Now, in the case of the situation I'm working on now, if the parent is correct and they did not consider these outside reports, and that's proven, then that team's going to get together again and look at those reports. And I'll probably direct them to have a facilitated meeting to make sure all that stuff is considered. The kid still might not qualify. but I'm going to make sure that they consider that outside information because that's required. So other highlights on written complaint is anybody can file it. And then if the district is out of compliance, there's two things we want to do, but we meaning the state. Number one is we want the district to be trained. So if the district made a mistake and it was an error of omission and they just didn't know that part or omitted that part of the process, we want to make sure it doesn't happen again. So the state is really big on training. The second part is how do we make it right by the kid? Well, the way you'd make it right by the kid is have that team meet and make sure they're considering all the information. And that comes out in something called a corrective action plan. And that directs the district of what to do and when to do it by. And here's the documentation we want. Once again, no cost to the district, no cost to the parent. We have 60 calendar days. And this is important because in some parts of IDEA, they'll describe school days and they'll describe calendar days. So in the center box there, in terms of written decision, it is 60 calendar days. And so if it was filed today, we would count 60 calendar days. And even if school's out of session for a spring break or whatever, the clock is still ticking. Christmas break, you know, the school might be out for 2 weeks. The clock is still ticking to get that complaint done. We try to do it quicker because both district and parent are anxious to hear the outcome. And but it depends on how many issues. In this case, the district will send me documents trying to prove, you know, that they were compliant. The parent's going to send me documents. So it'll be a combination of me looking at those documents and conducting interviews. And depending on the person or the location, it can be either in person or it can be virtual. Questions about that? I'm going to get out of here now. And I want to, I don't know how I'm doing time wise, but Kim and I had talked about allowing time for questions. I'd like to hear questions about any of the three in terms of facilitation, mediation, or a complaint investigation.
So Mert, if during the eligibility process and the facilitation, if it's come down that assistive technology needs to be assessed, is there a time period like with the others where you have 60 days, or is there a time that the district needs to get the assistive technology done?
Yes, unless, let's say that the team agreed to an assessment plan and assistive technology wasn't on there.
Mm-hmm.
Okay. And so you have your eligibility meeting and you review academics and cognitive and speech and all the other areas. And then at that eligibility meeting, the team says, gosh, we should have done an AT assessment. Then the parent has to sign permission for that. And the process would start again, although typically at that point, I see districts try to do an expedited assessment if they're just testing in that one area. But if it's on that original list of when they say parent district agree, here's the areas we're testing in, then you're on that 60-day clock.
Otherwise, it's just get it done as soon as you can.
Well, I would say functionally, yes, for a couple reasons. When you look at large districts like Boise, West Ada, I don't know about Idaho Falls, Elizabeth, but some districts are big enough that they have assistive
Right.
technology people in-house. On the other hand, I dealt with a district a smaller district, and they didn't have anybody in-house, so they had to deal with U of I,
Yeah.
where there's an assistive
Right.
technology unit. And it wasn't the district delaying, it was getting the U of I people on a schedule to get down there. And so in that case, district's obligation was to move forward as quickly as they could, look at other options, and mostly keep the parent involved. When I see parents get angry, it's if the district in this case didn't tell the parent, well, we've contacted U of I and it's going to be another 2 weeks. You know, we none of us like to be feel like we've been left out of the loop.
So so is it safe to say like within a month it should be done?
You know, I don't know. Is this a district that might have their own, or you
Yeah,
think
this is a district that has their own.
Yeah, I think it's fair to ask that question. So the AT part wasn't in the original assessment plan?
I don't know. I just
it-
know it took 4 months
Yeah.
once it was requested.
Oh, okay. Yeah, then I think it's fair to ask, you know, how long is this going to take? And yeah, you can certainly ask the question. If the district gives you a time and it seems unreasonable, you certainly can ask, you know, we consider this critical information. Help me understand why it takes so long.
Wow. Okay. Now, if we find that a district is having trouble in implementing one part of the IDA law, who does the training for the State Department?
The State Department almost exclusively uses SESTA.
SESTA does it? Okay.
SESTA does all the training, and they have modules. Is it about discipline and behavior plan? Is it about writing transition plans? Is it about when to provide written notice to parents? And so they have it set up in modules. And so sometimes they'll send somebody in person, and sometimes the district will do the module on their own. And then once again, they have to document who was there. Participants have to sign up. And so they can't just say we did it. I mean, they have to provide documentation.
Okay.
Any other questions?
I guess
Lisa,
I have more of
yeah.
a basic question
Sure.
because I would love to get my son in school. But yeah, I mean, is this a process? And this is outside of, facilitation, but beforehand, the steps beforehand, is that something I could start ahead of time in preparation for him starting school, like set up with what his process is going to be like? Because that's always been my biggest hesitation, is I don't want him to go a whole school year without, while we're waiting for them, and we need to wait 6 weeks before, and like with me, the special ed department of the charter school they said my neuropsych evaluation and all of his SLP was 2 years old, so they didn't want to use that. So we needed to, I'm just wondering if, what that could possibly be like, or do they really need to just get their hands on him themselves? I understand that too.
Did the charter school propose to assess? So if they're saying the information is 2 years old, first of all, we reevaluate children no later than every 3 years. So technically that information is current.
Okay.
And
Yeah.
so what you might look at, or what the charter school might consider, is school districts, like we have Letha here, and she's director in Valley View. She trains her staff in Child Find, and Child Find is part of IDEA.
Okay.
And so I guess the question I would have for the district is, it's okay to say it's 2 years old. We would like more current information.
Okay.
especially for younger kids because they change so
Yeah. Oh, yeah.
rapidly, right? So the kiddo that you knew 2 years ago isn't your child today,
Yeah,
right?
he's
But
grown up. Mhm.
you can,
Yeah.
as a parent, you can certainly say, I would like, to get ready for next year. I'm curious. Do I have a child with a disability? Is he eligible for a 504 plan or an IEP?
Okay. And I could do that possibly then if I am going to put him into a different school. I could maybe go to them now and say for next year, could we get an evaluation so he could be set up then
Yeah.
for that?
I see Letha is
Yeah,
there.
I'll answer on that. So
Yeah.
our process, you have to be enrolled in our school.
Okay.
So if you're talking about next year, if you fill out the online enrollment now,
Okay.
and you can't just say, well, I'm going to enroll next year. Now, will we meet with you now? Yeah, we'll meet with you right now, and we'll set a meeting date. First of all, as soon as teachers are back in August, to meet with you to get the process started. But we
Okay.
won't evaluate. We cannot evaluate or request records from anywhere unless you are a student at our school district. And
That
so,
makes sense. Mhm.
so unless you're actually enrolled, we won't start it. But we meet with people all the time that maybe are moving to our district or wanting to check out our services or this and that. Yeah, we'll meet with you and discuss it and describe the process to you, because we want to all be on the same page. But we won't start any testing until you actually are enrolled.
Okay. And so then in August, when the teachers are back in, that would be, what would that process look like? You'd have a couple of months of evaluation.
Usually I try to give my team no more than 2 weeks that we'll meet together and start the
Okay.
referral process.
Okay.
And then of course, then from that, from the team can decide at that referral meeting, do we need more data? Do we, as a team, do we agree to try some things with it? Because if the kid's never been in school, but we also would take in consideration your outside report, and that would play a strong role. And we would look at that. No, we need to go ahead. Sometimes when we're not sure if it's a 504 or a special education, we'll look and say, okay, let's try some accommodations. He hasn't been in school. We don't know how he's going to react. We don't even know what goals we're looking at, but we can go ahead and do some accommodations. If he has an outside diagnosis of autism or ADHD, we can talk about the things that you see at home, things that you might think will help. And we kind of rely on that, and maybe put a 504 in process, and then try some things, and then set a meeting date for a month later. Say, okay, let's come back to the table. Let's bring all our data, and where do we need to go from there? And of course, if there's behaviors and we see the kid acting out, within 2 weeks, we may not wait that whole month for that meeting, but we'll go ahead and set a date with you.
Okay. No, that's
What
Now,
information?
does Elizabeth have to put it in writing that she wants to have this meeting?
Typically, we do not request that. If a parent wants testing, we do like it in writing. But a lot of times, if we come to that first meeting, we're just going to set a meeting with you. You don't have to be in writing. Can you? I just, have it set up a meeting with you in the school and just talk about my child, and then maybe we set a meeting date in August to talk, to go forward. But it does not have to be in writing to request a meeting. We meet with parents all the time. Now, if the team, if she wants testing and that's all she wants and demands the testing, then we do like it in writing, because we haven't had a chance to get to know the kid, And so then we would come together in August and say, okay, you gave us a note that you want testing. Okay, we'll go ahead and do the testing, or we have the right to decline testing and say, these are the reasons why we won't test. But you're bringing outside information with you, most likely. I mean, our legal counsel advises us, if a parent, puts it in writing and comes to you, we're better off doing the testing than going just on an outside report, especially if it's 2 years old, because we have to show that there's an adverse impact at school. We have kids, at times, they give the parents holy heck at home, and they are angels at school.
Yeah.
They truly are. And we're thankful for that. We're thankful for that. And we feel bad for the parents, but we really cannot do anything unless we are seeing that adverse impact at school, and really a need for specially designed instruction. So, a lot of times, really your best teaching practice is really good teachers. You may not see that they need anything for a couple of years, and then all of a sudden, they start changing, the behavior starts changing, things start changing, the work demands start getting harder, the subject just gets harder for them, then you might see some things come out too. So, but I like to pride myself on that we'll recognize the problems before the parents will. So, we really do take pride in that and really want to work that we'll identify those students for you. When we say, okay, we're doing this and this and this, and they're not responding to those interventions, we need to go forward. And we really do pride ourselves on that.
Letha, what information could the parent be gathering to share with the district team, even though it may be somewhat dated?
Okay.
Would you recommend that they just bring any outside agency formal testing so your team can look at it?
Definitely want to see the outside testing because, especially if the testing's more recent, like let's say during the summer. Well, there's some tests that we cannot use in that fall even because there has to be a year between we give that same test, or 6 months at least before we give that same test, or it invalidates our test. So we definitely want to see the outside testing. If you have work samples, let's say that you've had them in preschool or that you've been working with them at home, if you have work samples or recordings of how, they won't read or how they twist the words around, or the writing samples and things like that, depending on the age of the child, if you have those actually, and they're coming to us brand new, we're definitely going to look at that, and we're going to have our occupational therapist there, and whether physical therapist, or if you're complaining about speech, we'll look at that. But we definitely need to observe and to know exactly where we're going. And it takes, a couple of weeks, 3 weeks to kind of get to know a child a little bit before we can kind of say, okay, yeah, we need to do this test, and this test. But we'll definitely observe them and try to get a better feel. But yeah, the outside reports, work samples, things like that are very, very helpful. And we want to know about what you think the strengths are and what areas. Be specific. Don't say, well, they have trouble reading, or, if they're older, say, is it the decoding? Is it understanding what they read? Try to be really specific in what your concerns are. Really helps us.
So I have a question on the testing. If a kid is in a charter school that is sponsored by the school district, then would the school district do the testing?
No, charter schools are their own LEA for the most part. So even though they might be sponsored by the home district, the charter school is responsible for doing their own testing. Now, we used to be the sponsor for Thomas Jefferson Charter School, and they were wonderful to work with. And so if a parent did not think that things are going the way they wanted, they did have the right to reach out to us as the home chartering district sponsor. And then, I would talk with them and say, hey, no, we need to do this, because sometimes maybe they're not as cognizant on the processes. But most of the charter schools in Idaho are sponsored by the Idaho Charter School Commission. Very few are sponsored by districts. You'll have a few that are, but not very many. But yeah, if you're not seeing what you want to see from the charter school, you can reach out to the home district if they are actually sponsored by them. But again, usually they'll reach out to us. I serve as the president of the special education directors for our region, and I'm also president of the Idaho Association of Special Education Directors. So, we work on training and trying to coach them, and reach out to us if you have questions and things like that. We really want to be a team with parents. That is our primary focus and objective here. We really want to parent. We really don't like it when parents come in defensive. Sometimes they come from other states and they got treated this way, this way, this way. Please give us a chance. Please talk with us. Please work with us. We're people too. We're doing the best we can. We do care about your child. They a lot of times spend a lot more of their time with us than they do at you. And that once they get into school, it seems like they're always, with us. And so we really want a chance to work with the parents. And that's what I really want to reiterate. We're a team. We really want to work with you.
Thanks, Letha. Any other questions or comments from the group?
I'm just curious, how you'll think this with the new legislation coming out is, there's going to be a lot of screening going on. Is this going to become a backed up system because of that new legislation?
In regards to dyslexia specifically? I talked to a psychologist who is also one of our contractors, and who I respect a lot. And I talked to her about it in terms of not just looking at a learning disability, but the uniqueness of dyslexia, either for evaluation or how you approach curriculum and instruction. And her comment, and she's very proficient, but also very open-minded, is it's going to be a learning process. As we, just like you look at how we interact with kids on the spectrum now, and even though there's still shortfalls, what the education system is doing today is so much more effective, I believe, than what it looked like 6 or 7 years ago. We've learned what works, what doesn't work. And I think it's going to be the same with dyslexia. And there's going to be, whether you're talking about the assessment part, are there certain unique tests that really do tease out the implications? The psychologists I talk with want to know that. You know, we test differently today for learning disabilities than we did before, where it was just, you know, kind of the deficit model. I think it's going to be the same with dyslexia, in my opinion.
Yeah, I'd like to concur with that. It's a learning process, and if all of us stick together, but you know, when you come in demanding testing, okay, you know, for one, is pulling them out, providing them special education, specially designed instruction, the best path? Or is it that we, as a school, we look at this as a school-wide process, let's design some interventions for students who show signs? Because when you say, my kid has dyslexia, well, that's one kid with dyslexia. Not just because that kid has dyslexia, it doesn't mean it's the same as that type of dyslexia. There are so many types of different dyslexia, whether it's a surface dyslexia or receptive dyslexia. There's all kinds. And so I just want to reiterate, patience with us. You know, let's point out the systems. Let's try some things that work, because we do try to buy top of the line curriculum. We try to stay current. A lot of our curriculums will already address a lot of that. We try to do a lot of visual. We try to do a lot of hands-on, a lot of repetition, breaking things down already, because it's just good teaching. But working with this in patience, and let's see if what we're doing is working. If it's not working, let's come back together as a team and problem solve this together. That's all we're asking for. Let's problem solve and let's work together. Because if I see every parent come in after the screening saying your kid, you know, shows signs of dyslexia, and then ask for testing, you're going to bog us down. You know, this kid, we can't test every single kid. We try. You know, I try to hire more school psychs all the time, and this and that. They're not out there, for one, but we can't keep up with it. So let's figure out what's working. And then, do they really need specially designed instruction? Do they really need pulled away from their peers? Or is there something that we can do better as a system as a whole? Because I see it as a general ed system core instruction that needs some strong interventions. I see it not as special ed issue as much as we need to improve our general ed and our interventions to address this, because there's a lot we can do that way before it gets to that's where they need to be pulled out and replaced with a totally different curriculum where they don't even fit in with their peers anymore.
Yeah, I have to agree with you, Letha, on that. Most of these dyslexic kids don't qualify for special ed. They might for a 504. But if you have that strong science of reading core curriculum with the gen ed classroom, you'll take care of a lot of these kids that have dyslexia, except for the real severe. So we just need to get the parents not to overreact. And we do, but unfortunately, we do have some school districts that will not recognize dyslexia, and those are the ones we're going to have to work with. I know your district is awesome. I've had people from your school district take my courses, and their knowledge is very much appreciated, because I don't have to tell them a whole lot. They know what they're doing.
Correct.
Thank you.
I know it's almost time to wrap up, but just to dovetail onto Kim's comments, when you're talking about whether it's doing testing and eligibility, or let's say the child qualifies, and the argument is about the amount of adult support or the curriculum to use, if both parents and district can ask questions first before you get into an argument. And Kim and I were talking before the session started. One of the examples we were talking about was curriculum. And I know certain parents believe that my child is dyslexic. They need a particular program, Linda Moot Bell, Orton Gilliam, and they have they've either been informed or done their research, and they believe that's the curriculum that's going to help their child to succeed. And let's say the district says, well, we use the XYZ reading program, and it's shown to be pretty successful. That could turn into an argumentative discussion. And so district could say, well, we don't consider Orton Gilliam, or this is the one we use and that's the one we're sticking to. Or a parent can say, well, I know Orton Gilliam's the best and I demand that. Or if I were facilitating a meeting like that, what I would encourage a parent to say, or first of all, the district to ask is, tell for Letha, she might say something like, tell me why you think it's so critical to have Orton Gilliam as the curriculum that we use with your child. Give me your thoughts on that. Then Letha and her team know what you're thinking. Here's how I see my child. Here's why I think Orton Gilliam is a match for that. Same for the parent. Rather than start the conversation with, well, Letha, I want Orton Gilliam and I don't want to consider XYZ. I would ask Letha as a parent, tell me why you think the XYZ program is going to be successful in terms of addressing my child's needs. Now, not just to Letha, but to the IEP team. What you find out at that point is, one, what does the team think about my child's needs? Are they seeing a fluency issue? Are they seeing comprehension? Are they seeing it as time on task? What's going on in their mind? And then why do you think the XYZ program is going to address his need? When you ask questions, you're getting ideas about the other person's thoughts, as opposed to starting with, oh, he needs an aid. He doesn't need an aid. He needs this curriculum. He doesn't. Because when it becomes argumentative, once again, the focus tends to go off the child. And I think it helps keep the focus, the discussion on the child when parents ask questions and when districts ask questions. Tell me your thoughts behind that. And that could reveal, now they may answer and you hate the answer, or you may disagree with it, but you know how they're thinking. And the same for the district. You may disagree with the parent, but that's okay. Now I've got a little more background. I know what, the concern is, he's just a really slow reader and he hates reading now and can't get him to do it. It gives you that background that I think leads more effectively to a collective decision.
Yes.
And nothing beats a good teacher. I mean, nothing beats a great teacher. You can buy me all the curriculum that you can stick on the shelves. You won't be a good teacher. And that's what's key to have in front of every child. And so, and let's use data, let's try something. And, 4 weeks later, if it's not showing that we're getting the growth and where we expect to be, then let's do something different. Let's not keep doing the same old thing, but let's find something that works.
Well,
yes.
I've talked a lot, and I think we've run up against the clock here.
Yeah, thank you, Mert. I do have a couple announcements. Dean Briganeer is going to be at the West Ada School District Office Training Center on July 19th in the evening to talk to caregivers, so it's parents, guardians, grandparents, teachers, about kids with dyslexia. It's from about 5:30 to 6:30 on July 19th. And then on July 20th, we're looking for 18 children between the ages of 11 and 14 who are dyslexic, and about 4 teachers, 4 to 6 teachers that would like to have a quick half-hour training to how to facilitate these kids doing an entrepreneur project. And it's from Dean's program is called Notice Ability. And if you just Google him and Google noticeability, you'll see the kind of programs that he does with kids. And then he's willing to give the curriculum out free. If there is a charge for this, it'll be nominal. We're meeting hopefully tomorrow to decide how much, it'll be less than 20 bucks. The other thing is on October 7th and 8th, the Idaho Council of Exceptional Children is joining with Decoding Dyslexia Idaho to do our fall conference or summit. And the October 7th will be virtual. And then October 8th will be at the West Data School District Training Facility, which is at the district office. And our keynote speakers are Jan Hasbrook and Dr. Nancy Mather. And we have about 12 breakout sessions. And so just keep watching. Once you sign up for one of our webinars, we send out the information to you. So hopefully you guys can attend. And with that, I'd like to thank Mert for spending some time with us and explaining things. So I have a better idea of what's going on and what I need to do. And I hope the rest of you got some great information. So with that.
Thanks for inviting me. I wish you all a great rest of your evening.
Thank you for your time. It was
Okay.
it took a lot of fear out of it.
Good.
But to
Good.
make it feel like, okay, this is a process that could really work. So thank you.
Yeah, we don't want to cause pain for anybody. So have a great rest of your evening, everyone.
All right.
Bye.
Thank you. Bye-bye.
Bye.